Welcome back to Legal English. In today's intermediate class, we're going to dive into the fundamentals of corporate law. One of the most essential areas for lawyers working with businesses, entrepreneurs, or international clients. We'll cover business entities, legal terms like liability and shareholder, and how to talk about company structures clearly and professionally. Here's what you'll learn in this lesson. You'll explore the different types of business entities used in corporate law and how to explain them in plain, simple, but precise English. We'll introduce key terms like shareholder, incorporation, liability, and show you how to use them fluently. Then we'll compare common structures like corporations, LLCs, partnerships, so you can confidently describe how they work. And finally, we'll focus on a bit of grammar, specifically relative clauses and noun phrases, tools that help you sound more professional when talking about business law. When I meet with clients who are starting a business, I usually begin with a few key questions. First, what kind of business are you planning to run? A consulting firm, a product-based startup, a small service business? That helps us choose the right legal structure from the start. Then we talk about legal steps, because forming a company isn't just about getting a name or a logo. It often means choosing between options like sole proprietorship, a limited liability company, or a corporation. And here's why it matters. Choosing the right structure gives you legal protection, tax benefits, and more flexibility. For example, an LLC limits your personal liability. So if the business is sued, your personal assets are generally safe. This is very important to explain to clients. But if your client runs their business without any formal legal structure, that can be very risky, and they might be responsible for debts or lawsuits, and they'll miss out on key protections and tax options. So in this video, we're going to break down the different options and help you understand the legal fundamentals of business formation in clear, professional English so you can explain it to your clients. Let's start with the word shareholder. A shareholder is someone who owns shares or part of a company. This means they have a financial interest and some rights. For example, voting on major decisions. The shareholder voted to approve the company's annual report. Shareholders are key players in corporate governance because their ownership gives them influence over the company's direction. Next word, incorporation. This is the legal process to create a company or corporation or LLC. Once a business is incorporated, it becomes a legal entity separate from its owners, which offers protections and responsibilities. Here's an example. Incorporation gives a business its legal identity separate from its owners. This process is essential to protect personal assets and define the company's rights and duties. Now let's look at the word liability. Liability refers to the legal responsibility a company or its owners have for debts or legal obligations. In many companies, like corporations or LLCs, liability is limited, meaning shareholders or owners aren't personally responsible for business debts or problems. For example, limited liability means shareholders aren't personally responsible for the company's debts. Understanding liability helps clients know their risk exposure when starting or investing in a business. Next, we have legal entity. This term means that the company itself is recognized by law as a separate person. It can enter contracts, own property, sue, or be sued independently from its owners. For example, a corporation is a legal entity that can enter contracts and own property. This separation is what makes corporations different from sole proprietorships or partnerships where the business and owner are legally the same. Articles of incorporation. Let's talk about articles of incorporation. This is a key legal document filed with the government to officially create a corporation. It typically outlines the company's name, purpose, structure, and key rules. For example, the Articles of Incorporation define the company's structure and purpose. This document is essential because it sets the foundation for how the corporation operates. Finally, we have the Board of Directors. This is a group of individuals elected by shareholders to oversee the company's management and make high-level decisions. For example, the Board of Directors makes important decisions about the company's strategy. The board acts in the shareholders' best interest and ensures the company runs effectively and legally. Let's practice corporate law vocabulary with these sentences. First, who is part owner of a company and may receive dividends? The answer is shareholder. So we say a shareholder owns shares in a company. A shareholder is a person or entity that owns part of a company. This ownership usually means they have voting rights and may receive dividends, which are payments made when the company earns profits. Shareholders are essential because they invest capital and have a say in companies' decisions. Next, what document officially creates a corporation and sets out its rules? The answer is Articles of Incorporation. So we say the Articles of Incorporation define the company's structure and purpose. And the Articles of Incorporation are legal documents filed with the government to formally establish the company as a corporation or an LLC. This document is very important because it contains, for example, company's name, purpose, share structure, and it's the company's foundational blueprint and a key step in becoming a legal business entity. Let's continue practicing corporate law vocabulary. Think about this question. Who is responsible for managing and overseeing the company's operations? The answer is Board of Directors. So we say the Board of Directors makes important strategic decisions. The Board of Directors is a group of individuals elected by the shareholders to govern the corporation. They set policies, make major business decisions, and oversee the company's overall direction. Think of them as the leadership team that guides the company's future. Next, what do we call a company that has its own legal identity separate from its owners? The answer is legal entity. So we say a corporation is a legal entity, which means the company can enter into contracts, own property, and be responsible for its debts independently of its owners. This separation protects the owners and allows a business to operate on its own legal footing. Let's keep practicing with two more important terms. First, what term means being legally responsible for a company's debts or actions? The answer is liability. So we say liability means legal responsibility for debts or damages. Liability defines who must pay for losses or damages the company incurs. In corporations, shareholders usually have limited liability, which means they aren't personally responsible beyond their investment. This protection is a key reason why many choose to form corporations or LLCs. Next, what is the process of legally forming a corporation? The answer is incorporation. So we say incorporation is the legal act of creating a company. Incorporation involves filing the necessary legal documents like articles of incorporation with the government to establish a company officially. This process gives the company its legal identity and sets the foundation for its operations. Let's work on a bit of grammar now. Let's start by understanding what a relative clause is. A relative clause adds extra information about a noun, explaining more about who or what we mean. We use relative pronouns like who when talking about people, that or which for things, and whose to show possession. These little words help connect the extra details to the main noun smoothly. Here are some examples of relative clauses in English. A shareholder who owns more than 50% can control the vote. The clause who owns more than 50% tells us exactly which shareholder we mean. And a clause that is unclear can cause legal disputes. The phrase that is unclear describes the kind of clause. And then the client whose documents were missing had to reschedule. Whose documents were missing, whose shows possession. It tells us whose documents they are. Using relative clauses like these helps you give clear, precise legal explanations. Let's now practice what we just reviewed, relative clauses. These are short phrases that help give us extra information about a person, a thing, or group. And in legal English, they're key to speaking clearly and precisely. For example, the client who arrived late didn't bring the required documents. Here, we're identifying exactly which client we're talking about, the one who was late. You'll use words like who, which, that, or whose, depending on what you're describing. Remember, we use who for people, which for things, that for people or things in defining clauses, and whose to show possession. So when you say the contract which was signed yesterday includes a confidentiality clause, you're using a relative clause that begins with which. That little phrase, which was signed yesterday, tells us exactly which contract we're talking about. In corporate law, you might have multiple agreements, and so being specific, using a clause like which was signed yesterday, helps everyone stay clear on the facts. This is what we call a defining relative clause. It gives essential information that identifies the subject. Now look at this one. The lawyer whose office is in San Jose specializes in corporate law. Here, we're using whose to show possession. It connects the lawyer to their office. We're not just talking about any lawyer. We're talking about the one who owns an office in San Jose. In legal conversations, especially when describing professionals or businesses, relative clauses like this keep things clear, organized, and accurate. And that's exactly what legal English is all about. Let's look at one of the most useful tools in legal English, the noun phrase. A noun phrase is a group of words that works together as one noun. It's made of two parts: a core noun, the main idea, and descriptive words that give more detail. Here's an example. Limited liability protection. The core noun is protection, and the words limited liability explain what kind of protection we're talking about. Why are noun phrases important? Well, it's because legal English needs to be precise and efficient. Instead of saying, this is protection related to limited liability, which is a lot to say, we simply say limited liability protection. Much clearer, much more professional. Here are a few more. Corporate governance structure. How a company is governed. Shareholder voting rights. The rights shareholders have when voting foreign investment policy. Rules for investing from outside the country. You'll see noun phrases everywhere in legal documents. They help pack complex ideas into clear, compact expressions. So here's the pro tip. Use noun phrases to sound more like a lawyer. They make your language stronger, cleaner, and more formal. Let's practice using noun phrases by looking at some real examples from corporate law. First, employment contract terms. Here's the sentence. The employee disagreed with the employment contract terms related to termination. These are specific parts of an employment contract, things like salary, working hours, benefits, and termination procedures. If a contract isn't clear or seems unfair, it can lead to a legal dispute. Knowing how to describe these issues precisely is key in legal communication. Next up, intellectual property dispute. Example sentence: they hired a law firm to handle the intellectual property dispute with the former employee. This phrase refers to legal conflicts over things like trademarks, copyrights, or inventions. In this case, maybe the former employee shared trade secrets or claimed ownership of company ideas. These disputes are common in tech, design, and media industries, and knowing how to explain them clearly is essential. Let's continue with two more legal noun phrases. First one here: regulatory compliance procedures. Here's the example. The company updated its regulatory compliance procedures to meet new data protection laws. This refers to the steps a business takes to follow legal rules, especially in areas like privacy, safety, or finance. If a company fails to follow these, it could face audits, fines, or lawsuits. So it's a very important phrase in compliance work. And finally, merger approval process. The merger approval process required several months of review by antitrust regulators. This phrase describes the steps a company must follow to get legal permission to merge with or acquire another company. Regulators, often government agencies, review these deals to ensure fair competition. Using phrases like this help you talk about complex procedures with clarity and confidence. Now, let's review 5 common business structures and match them to their legal features. First, which structure has a board of directors and can sell shares publicly? That's A, corporation. Corporations are formal entities. They offer limited liability, can raise capital by selling shares, and are managed by a board. This is the model used by large companies like Apple or Coca-Cola. Next, which type of business is owned and operated by one person with full personal liability? That's D, sole proprietorship. This is the simplest business form, but be careful. If the business has debts or gets sued, the owner is personally responsible. Now, which type of organization is created for public or charitable purposes and is usually tax exempt? That's E, nonprofit organization. These entities don't distribute profits to owners. Instead, they reinvest in their mission. In Costa Rica, for example, you can think of foundations or associations. There are also charities or educational institutions. Let's finish the matching activity with the last 2 structures. Which business is managed by members or managers and offers limited liability with fewer formalities? That's B, limited liability company, or LLC. This structure is popular because it combines the protection of a corporation with the simplicity of a partnership. In many countries, it's called an SRL. And finally, what structure is used by professionals or families and may involve unlimited liability? That's C, partnership. In a general partnership, each partner can be personally liable. These are common among law firms, doctors, or family-run businesses. There are also limited partnerships where some partners only invest money. Understanding these structures helps you explain the risks and benefits clearly when advising a client or evaluating a company. Let's wrap up this section with a quick snapshot of how businesses are governed and why this structure matters. So imagine you're advising someone who's about to start a company. One of the first questions is, who gets to make the important decisions? In a corporation, the power usually sits with the board of directors. These are people elected by the shareholders to make high-level decisions, things like approving budgets, hiring executives, or expanding the company. Now compare that to an LLC or limited liability company. These are much simpler. Instead of a board, the day-to-day operations are handled by one or more managers. It's more flexible, and often it's better for smaller businesses or startups. At the heart of any corporation is a key document, the Articles of Incorporation. Think of it as the company's rulebook. It explains the ownership structure, outlines shareholder rights, and describes how liability and voting are handled. But no matter which structure you choose, there's one big advantage: limited liability. This means the owners usually aren't personally responsible for business debts. So their homes, cars, and personal savings are protected if things go wrong. Understanding these ideas helps you talk confidently with clients about their options and explain not just how to start a business, but how to structure it for success. Let's reflect a bit and apply what we just learned. Imagine you're advising clients in each of these situations. First, a solo entrepreneur wants to open a small coffee shop. They don't have much startup capital and want to keep things simple. You might suggest here a sole proprietorship. It's quick to set up, but you need to explain the personal liability risks, so maybe an LLC would be better for them. Second, a group of investors is building a tech startup. They plan to raise money from outside investors and grow fast. That's where a corporation makes the most sense. It allows them to sell shares, limit liability, and attract funding. Third, a family of lawyers wants to form a small firm. They'll share profits and responsibilities. A partnership or a professional LLC could work well here, depending on how much liability protection they want and how they'll divide decision-making. This kind of thinking is what lawyers do all the time, matching the structure to the client's goals. So take a moment to review the vocabulary and think which structure fits each scenario best in your opinion and why. Let's start with a powerful idiom, break the glass ceiling. This phrase is often used when someone reaches a position that was traditionally closed off to people like them, especially in terms of gender or race. In corporate law, we hear this when someone becomes the first in a leadership role, like CEO or partner at a firm, despite the odds. For example, she, the woman, broke the glass ceiling when she became the first female CEO. This isn't just a win for her, it often signals broader change within an organization or an industry. Next, we've got a very common financial idiom, in the black. It means the company is profitable. It's making money. It makes more money than it spends. For example, after restructuring, the business is finally in the black again. In legal or financial reports, this is a good sign. It means the business is healthy, making money, and likely compliant with its obligations. The opposite would be in the red, which means losing money. Take the helm comes from sailing, but in business, it means to take charge. We use it when someone steps into a leadership role or assumes responsibility for a team or organization. An example, he took the helm after the previous director resigned. This often happens during a transition. Maybe there's a crisis, or the company just needs fresh leadership. It's a powerful way to say someone is now in command, in control, leading. Under the radar means operating quietly, without drawing attention. Sometimes businesses do this deliberately, maybe to avoid competition or media scrutiny. For instance, the startup stayed under the radar until its product went viral. In legal terms, it might also relate to compliance. Is a company intentionally avoiding scrutiny or just not on anyone's radar yet? Either way, it's about staying low profile. Uphill battle paints a picture. Imagine trying to climb a steep hill. It's tough, exhausting, and requires persistence. We use this idiom when talking about big challenges in the business world. For example, getting investor approval was an uphill battle. In corporate law, you might hear this when negotiating contracts, defending a merger, or overcoming regulatory barriers. It means the process was tough, but hopefully worth it. All right, let's bring these idioms to life with a short story. Remember the ones we talked about. When Maria took the helm at Veritas Tech, the company was struggling. It had been operating under the radar for years, not because it was secretive, but because no one believed it could compete with the bigger firms. Maria, however, had other plans. She streamlined the product line, restructured the legal team, and worked close with corporate counsel to secure key partnerships. It was an uphill battle. Investors were skeptical, and internal resistance slowed every decision. But within 2 years, the company was finally in the black, reporting solid profits for the first time in 5 years. And Maria, she broke the glass ceiling by becoming the first Latina CEO in the industry, opening the door for future leaders to follow. Before we wrap up, let's review what we covered today. First, we explored essential corporate law vocabulary, words like shareholder, liability, articles of incorporation, and board of directors. These are the building blocks of professional legal communication when working with business and corporate clients. Then we compared business structures, corporations, LLCs, and partnerships. You learned how they're different in terms of ownership, liability, and governance, and how to explain those differences clearly to a client. We also worked with grammar tools lawyers rely on every day, relative clauses, and noun phrases. They help us sound precise and professional, whether we're drafting a contract or giving legal advice. And finally, we brought it all together by thinking about how to communicate clearly with clients, especially when explaining tricky and difficult topics like incorporation, liability protection, and how a company is legally structured. Great work today. You're really building a solid legal English foundation.